Thank you very much, Taylor. Good afternoon to those of you joining me from the East Coast. As you can see, I am a senior associate in the Syracuse office of Tully Rinckey, where I practice in the area as civil litigation. Prior to joining Tully Rinckey, my principal areas of focus involved corporate advisory and transactions, including formation, governance, and compliance, commercial transactions and disputes, some regulatory enforcement defense, and civil proceedings generally across a wide range of matters, including securities and insurance defense. Our presentation today, as you can see on slide number 3, will focus on the U.S. Department of the Treasury's Financial Crimes Enforcement Network's final reporting rules issued on September 30, 2022, as amended on November 30, 2023, under the Corporate Transparency Act, enacted January 1, 2021, as part of the larger Anti-Money Laundering Act of 2020, subsumed in the National Defense Authorization Act for fiscal year 2021. That's a lot of information there, but it is indicative of the progression of the Corporate Transparency Act through Congress since it was first introduced, or the idea of beneficial ownership information was first raised decades ago, and has since then become what we have today in the latest version of the Act, and of course the Department of Treasury's regulatory rules that went into effect January 1, 2024. We'll delve into the purpose, background, and rationale of the CTA, as you can see, what the CTA requires, including who's required to file beneficial ownership information reports, or BOIRs, with FinCEN, the Financial Crimes Enforcement Network, and present deadlines. We'll also discuss generally who's exempt from reporting and highlight some key compliance issues involving real estate transactions and penalties for reporting violations. I'll then conclude with some practical advice and best practices to navigate current reporting rules, and we'll take any questions. You can review the timeline on slide 4 yourselves. I will not read through each one of them, but essentially this includes a timeline of U.S. and multilateral initiatives designed to collect beneficial ownership information via customer due diligence protocols pursuant to anti-money laundering statutes, including bank secrecy legislation. I provided it as further background to demonstrate that establishing reporting rules or reporting standards of beneficial owners is not new in the United States. A part of customer due diligence for existing financial institutions, for instance, such as banks, broker-dealers, mutual funds, and futures, commission merchants, and commodities brokers already require identifying and verifying the identity of its customers. However, states and those other than covered financial institutions under bank secrecy laws do not collect beneficial ownership information, or BOI, when entities are formed. So FinCEN will now be collecting this information with the assistance of the private sector. Slide 5 provides a brief history of where we are at the present time and how we got there. Very briefly, during World War II, the use of offshore bank and other offshore banks allowed nest eggs for some of those able to escape persecution during World War II we're all familiar with the concept of Swiss bank accounts. Other examples were of those facing war, civil, political unrest, confiscation, taxation or expropriation in their home countries over the following several decades, including from the former Soviet bloc. Growth of an offshore trust industry, rather, and tax havens, promising confidentiality and security, therefore grew. We're familiar with perhaps Bermuda and Barbados being the closer to us, but there is no shortage now, even domestically, as we note in Delaware and some states in the West that encourage the sort of filings of shell entities that the Corporate Transparency Act has been designed to target and to try to identify the beneficial owners for law enforcement purposes. The subject here is money laundering, and again, the Corporate Transparency Act was designed to counter criminals' use of corporate structures in the U.S. and overseas as shells to evade detection and funnel money through the United States to fund illegal activities. As you can see on the slide here, I've included some data, but frankly, money laundering, which is along with finance of terrorism and other illegal activities, it typically includes, or the funding of these activities typically includes, essentially exchanging dirty money for clean money, such that the flow, as we all know, hides the source of the illicitly earned money, usually drug money through a shell company, shell company's account rather, as fake sales orders, and then converting it into or allowing it to enter into the U.S. Financial system. Less typically, though, laundered money can also be legitimate money used to promote unlawful activities within or without the U.S. And of course, that is terrorism funding. As I mentioned, the CTA was enacted as part of the Anti-Money Laundering Act of 2020 and the National Defense Authorization Act of 2021, and requires that certain entities file reports with FinCEN that identify two categories of individuals. These are real persons, natural persons, namely beneficial owners, otherwise known as those who ultimately own or control the entity, and company applicants, those who created or registered the entity for companies created before January 1, 2024. I'll briefly add here, reporting companies do not need to identify company applicants, but after January 1, 2024, a reporting company's beneficial ownership information report has to include the names of the company applicants, and we'll define those terms later. On page, well, let me just conclude before we leave page 5 by saying that the Act became effective, of course, January 1, 2024, but I wish to remind everyone that it was intended to aid law enforcement, again, in combating illicit activity conducted through smaller, otherwise unregulated, anonymous shell companies. This act, in other words, wasn't targeted or focused on capturing large entities already regulated by some way by the federal government. So it's primarily going to focus on small companies, corporations, LLCs, LLPs, LPs rather, in an effort to allow, well, we're not asking banks and others who are subject to this statute to become law enforcement, but it's to provide law enforcement with information that it can then use to try to identify and prevent illicit money transactions in the United States. On slide 4, without having to go back, you can review it yourselves later. The subject of combating money laundering in the United States really did not come to the fore until June of 2006 or so. It is brought, of course, to Congress's attention by an intergovernmental organization. The Financial Action Task Force is an intergovernmental organization created around 1989 or so by the G7, as it reads, to develop policies to combat money laundering, and in 2001 extended that to terrorism financing. The U.S. was viewed as a laggard in this area, whereas the European Union had already created and addressed beneficial ownership concerns there. The U.S. took some time before it agreed to do that. It's culminated now in the CTA, and as slide 6 demonstrates, it is focusing on small entities or certain privately held entities, otherwise known as reporting companies in the rules, to report beneficial ownership information to the U.S. Treasury Department's Financial Crimes Enforcement Network through its beneficial ownership technologies system. So this is going to be an electronic system that beneficial owners or their agents will enter in beneficial ownership information, and we'll get to what that includes later. The CTA directs that Treasury Department maintain beneficial ownership information in a secure, non-public database at the highest security level for non-classified information accessible to law enforcement and others granted permission. In other words, private individuals, attorneys, accountants, even state agencies will not be able to access this without special permission, and state agencies only civil and criminal enforcement matters at the request of federal agencies. So this is a very, very tightly secured electronic system, or at least as much as it can be, that won't allow, in many cases, in most cases, I suspect, because we do not have a lot of instruction or determinations from FinCEN or the courts exactly what can be disclosed, but it's fairly certain that Freedom of Information Act will not get you information on a reporting company to allow folks or give folks concern that their private information will be disclosed, or to allow those of us out here who sometimes seek that information to avoid skip tracing or other legitimate means to get corporate information or reporting company information on individuals. So who is required to report? Under the CTA, both domestic and foreign entities can be reporting companies. So domestic reporting companies are defined as corporations, as I mentioned briefly before, limited liability companies, or other entities created by the filing of a document with the Secretary of State or any similar office under the law of either the United States, a state of the U.S. rather, District of Columbia, a U.S. territory, or any Commonwealth of the U.S., as well pursuant to any tribal authority. Filing a document with a government agency to register a DBA or to obtain an employer identification number, for instance, or a professional business or occupational license, does not make the filing party a reporting company, since those are not necessary to form or create an entity. Furthermore, the Act does not target sole proprietorships at this point. Common law trusts and general partnerships are not reporting companies either. However, there are rumblings afoot to possibly extend or remove any of these companies from the list that currently are not required to report and include them later. It's really at this point uncertain where FinCEN will go with it. Sole proprietorship, as I mentioned, sole proprietorships and limited partnerships, I beg your pardon, general partnerships generally do not file with secretaries of state. So this is why those two entities are exempted. Again, however, this may change. In fact, the Money Laundering Act specifically calls for further study of trusts, partnership, and other legal entities within 2 years of the reporting rules effective date of January 1, 2024. So on or by December 31, 2025, we may see further expansion of the types of companies that will have to file. We'll talk about those we know are exempt in addition to the entities we've just talked about a little later. But each reporting company must file its own BOI report. A parent company cannot file for itself in any of its subsidiaries. We'll get into that. Foreign reporting companies are non-U.S. entities, of course, that are corporations, LLCs, or other entities that are formed under the law of a foreign country and registered to do business in any state or tribal jurisdiction by the filing of a document with the Secretary of State of that state or tribe under the law of a state or tribal document. Slide 7 will show you exactly what reporting rules and key dates we're looking at here. The same beneficial ownership interest report is used regardless of what type of filing that a beneficial owner is making, either initial report, an update, correction, or to note loss of an exemption that would require that it report. The report or the application on the BOIE website will allow you to indicate which type of filing you are making on the report. And again, the reporting requirements came online on January 1, 2024, or the effective date of the CTA. Again, if we're looking at slide 7, you will see initial reporting includes a reporting company that is created or becomes a foreign reporting company if before the effective date of 1/1/24. It has until January 1, 2025 to file its initial BOI report. Those created on or after the effective date, that's companies created on or after the effective date, must file its initial BOI report within 90 days. So those companies formed on or after January 1, 2024 have 90 days in which to file their BOI report. That is only for 1 year, however. I should note that any companies created or registered in 2025 will have 30 days in which to file thereafter their beneficial ownership reports. Yeah, initial reporting also includes a requirement that reporting companies file updated reports when it receives actual notice that its creation or registration is effective by a Secretary of State. So any company filed on or after January 1, 2024 is required to file within 90 days of receiving notice from the Secretary of State, either in a published form in newspapers or confirmation via the Secretary of State website that its creation or registration is effective, which may not necessarily be the same date of filing. Updated reporting. Again, looking on page 7, updated reporting requires that a reporting company file its updated report within 30 days to report any changes to information in its initial filing regarding itself or its beneficial owners. The 30-day period starts on the day of change, regardless of the owners or the controlling party's actual or constructive knowledge of the change. In other words, the CTA and the rules presume that a company knows who their beneficial owners are. Good faith is not an excuse, and I believe it's part of the regulation. So whenever that happens, whenever there is a change to the information in a beneficial owner's status, including a change of address, they are required to file an update to its BOI report. Interestingly, at least to those of us who file or form companies, an updated filing is not required to change a company applicant's information of reporting companies formed in 2024. In other words, the updating requirement applies to reporting companies formed after January 1, 2024. Those entities formed before January 1, 2024 do not need to report the names of those who actually created or formed the company or who directed the formation of it. It is only going to require, again, for companies created before January 1, 2024, the names of the beneficial owners. And a definition of who beneficial owners are, we'll get to in a moment. Updated filing is further discussed later during a discussion of safe harbor and penalties for filing corrective reports to correct any inaccuracies in the initial BOI report. If it becomes aware or has reason to know the accuracy, is permissible if the inaccuracy is discovered within 30 days as well. An updated filing to correct inaccuracies or changes to information in a BOI report requires filing an entirely new BI report. You cannot merely notice the change. So using and saving the BOI template or PDF version available through the FinCEN website is probably a simpler process. Examples of events potentially requiring update of your BOI report. I've determined that it's safe to assume that any shareholder change over or under the 25% threshold and beneficial ownership or ownership of a reporting company has a 25% threshold range. So those who own 25% or more of a reporting company are deemed to be beneficial owners. Other examples of events that potentially require updating your BOIR report is a sale or merger of the company. That would be self-explanatory. Stock grants to employees affecting beneficial owner application, change in officer duties and authority. In other words, creation of additional senior officers or deem those to have substantial control of reporting companies. Change in board composition, if the composition or change affects reported substantial control parameters. Issuance of debt obligations, change in credit terms, contracts with third party affecting the control of the company. In other words, there are LLCs or pooled investments in real estate context in which there will be additional or supplemental funding besides that of the sponsor or the general contractor on the project that may result in some substantial control issues that were not originally in the formation document. This would require an update with FinCEN. Simple changes of address, as I mentioned, for business or beneficial owners will also trigger the need to update. The list goes on and on. It is really perhaps useful to mention here that there is pending congressional action to slow down the implementation of the CTA. There has been hard pushback from various organizations seeking to extend the 90-day deadline to report changes in the BOI, for instance, as well as proposals to delay reporting requirements by existing reporting companies to January 1, 2026. So essentially, give everyone an additional year and FinCEN 2 to figure out the scope and how the regulations and rules are to be interpreted. Moving on to slide number 8, the reporting requirements. The filing of a BOI report can be done in a couple of ways. You can do that by fillable PDF, upload to the FinCEN site, and I believe, yes, I have the website that you can review for yourself. That contains both the filing page and step-by-step instructions for completing that. But you can fill out a PDF, upload it, or keep it live on the FinCEN website and just enter it and not save it and print it. Again, you can save and resume completing a PDF by downloading it to your own computer, but you cannot do it through the live or the web version. So those companies that are contemplating filing an initial CTA report are cautioned to probably want to have beneficial ownership information, company applicant information, and all the uploadable supporting documents, which we will describe in a moment, available, so that when they're completing the form, they can just get through it as quickly as is humanly possible and without having to save, download, and resume. Not that it appears to be, frankly, a ponderous website, but at the same time, there is much information that's requested that a lot of individuals just do not often have at their fingertips, including identifying information numbers from state or federal authorities that will also have to be submitted. Once you've submitted a BOI report through the FinCEN website, FinCEN will provide an acknowledgement of submission, success or failure, and a transcript of the report. Filing can be done by an employee of the reporting company, the owner, or a third-party service provider, or anyone authorized by the reporting company, such as a law firm, to act on its behalf. The filing individual must provide the following basic contact information, either which includes their name and email address or phone number. The slide 9 talks briefly about what we're calling a FinCEN identifier. This is a document similar, I suspect, to our Social Security numbers or EINs that a reporting company may obtain for future use. And a company would do that by checking a box on its initial beneficial owner report requesting a FinCEN number. It essentially will then save all of the beneficial ownership information you've entered in your initial report and obviate or prevent the need from having to re-enter it again during any updates or corrections, other than to note the correction in the update report. It's for reporting companies, it's not one's not allowed to obtain it in advance. So the initial report or the initial filing to FinCEN will have to include all of the beneficial ownership, company applicant, and supporting documents that the form requests. It would be advisable, I would think, for a reporting company to obtain a FinCEN number and refer to it in subsequent filings. If, for instance, the reporting company is a subsidiary or a holding company of others, in which case you will be making multiple filings, potentially several times a year, and will want that information entered once and not risk having any mistakes in any re-entries or potentially allowing any bad actors or malign forces to gain access through whatever means they can during your upload of this material. I'd like to mention just briefly here that individual may also obtain a FinCEN identifier number, but they do not need to, of course, have filed a beneficial ownership interest initial report in order to do that. And all they will have to do is log in to the site I identified here and provide the information, and you will have a FinCEN number to use when you make reports on behalf of third parties. In the case of companies that will be doing this as a regular course, including law firms, CPAs, I suspect that it would behoove us to each obtain a BOI or a FinCEN number to assist reporting companies, and particularly those reporting companies in which an individual holds an ownership interest in the entity, to allow him to keep his or her information at his fingertips without having to keep a database of that. Moving on to slide 10, BOI requirements. The BOI report must include information about the reporting company, which includes a legal name and any trade name, current address, the street address of the principal place of business, if in the U.S. Or if outside the U.S., its U.S.-based headquarters, the jurisdiction of formation or registration, taxpayer identification number. If a foreign reporting company has not been issued a taxpayer identification number, a tax identification number issued by the foreign entity, and the name of that jurisdiction. Information about beneficial owners, on the other hand, requires the name, the date of birth, the residential address of the beneficial owners, an identifying number from an acceptable identification document, such as a passport or one of our new U.S. driver's licenses, and the name of the issuing state or jurisdiction of the identification document. An image of the identification document used to obtain the identifying number. So a photograph, the rules are unclear, but a photograph, I suspect, of the front and back of the driver's license or the identifying or the holder's identifying page of a passport will suffice. Whether it has to be clear or legible to a degree that's been not ill-defined or undefined in the rules is to be determined. But nonetheless, an image has to be provided, and then information about the company applicant for reporting companies created after 1/1 or January 1, 2024. The definition of beneficial owner under the CTA. We're getting to a point in the presentation that is going to be of most interest to folks, since there are 33 million or so entities out there that FinCEN anticipates will be interpreting these final rules to identify what a beneficial owner is under the Act. Well, What it is, with respect to an entity, a non-exempt entity, an individual who directly or indirectly through any contract, arrangement, undertaking, relationship, or otherwise exercises substantial control, which will be defined, over the entity, or owns or controls not less than 25% of the ownership interests of the entity, as we earlier mentioned. Reporting rules, the reporting rules, FinCEN's reporting rules, the final rules adopted in September 2022 as amended in November 2023, definition of beneficial owner is substantially the same as the definition in the Act itself. The Act, the CTA, does not, however, define what substantial control, directly or indirectly, or ownership interests mean, but those terms are addressed in the reporting rules, and we'll go into them now. The next couple of slides, if you're following along, 12 and 13, define ownership interests. And ownership interest is defined as one including any equity, stock, or similar instrument, pre-organization certificate or subscription, or transferable share of, or voting trust certificate or certificate of deposit for an equity security, interest in a joint venture or certificate of interest in a business trust. Of course, let's be clear that in each of these cases, this is without regard to whether any such instrument is transferable, is classified as stock, or anything similar, or confers voting power or voting rights. What I've interpreted this to mean is that what it is called is not so important as what it actually does. And if a warrant or option or exercisable gives someone in a company an ownership interest of 25% or more, either directly or indirectly, that individual will be deemed to have an ownership interest and therefore is a beneficial owner. Of course, it also includes any capital or profit interest in an entity. Individuals who, while not exercising any voting or direct voting or initiation rights under management clauses, may nonetheless be entitled to capital or profits with an entity, in which case they will be deemed a beneficial owner. There are other items in the Act, in the rules, excuse me, that identify how ownership interests can be obtained other than equities or entitlements to capital. And I'll just briefly mention a few here. Any instrument that is convertible with or without consideration into any share or instrument described in the Act or the rules, or any future on any such instrument, or any warrant or right to purchase, sell, or subscribe to a share interest described in the rules, regardless of whether it's characterized as a debt. So it looks like FinCEN is interested in identifying individuals who are lying very low beneath the organization structure and cannot be found in the governing documents, and yet have a controlling interest in how much debt the company carries. Any other instrument, contract, arrangement, understanding, relationship, or mechanism used to establish ownership. This is the catch-all phrase that most of us who've looked at this are scratching our heads about, because it is not defined anywhere. So essentially, any other creation that provides and allows an individual or grants an individual an ownership interest, a measurable ownership interest above 25%, will be considered having an ownership interest, and therefore satisfying one of the prongs of the beneficial ownership definition. Slide 14, I've taken the opportunity to include this information because it specifically identifies individuals who are not are not considered to be beneficial owners. And perhaps the first one is an obvious choice: a minor child. Until that individual reaches the age of majority, that is, and as defined, of course, under the law of the state or Indian tribe in which the reporting company is created or the foreign company is registered, if the child's parent or guardian information is provided. An individual acting as a nominee, intermediary, custodian, or agent on behalf of another individual, of course, is another accepted entity, and an employee of a reporting company, CT Corp, in other words, acting solely as an employee and not as a senior officer, whose substantial control over economic benefits from such entity are derived solely from the employment status of the employee. I think an important exception, and I'm not sure if it's identified on the screen or not, is the creditor of a reporting company. As we'll see in the exemptions to companies that do not have to report, I believe there are 23 or so of them. They appear to be those larger companies, obviously, that were intended or are regulated otherwise, others publicly reported companies, or regulated entities such as banks, that are well represented in Congress and therefore are exempt from reporting. A gray area, though, are creditors of reporting companies, and it's unclear, and FinCEN will issue other guidance eventually. The courts will weigh in as well. But what if creditors such as banks, in many cases, they do sit on asset protection committees and veto power of sales of assets, which are secured by loans from financial institutions? Will they be deemed to have substantial control, significant enough, directly or indirectly, to fall within the beneficial ownership interest? And on slides 15 and 16, we get into what the definition of an individual with substantial control actually means. Definition of substantial control, and again, beneficial owners are defined as either those owning 25% or more of a reporting company, or those having substantial control over it. So an individual exercises substantial control over a reporting company if the individual either serves as a senior officer of the reporting company, and as we'll see, that is a defined term, has authority over the appointment or removal of any senior officer or majority of the board of directors or a similar body. This often falls at the discretion of the general counsel, or perhaps a committee of the board of directors, or has or directs, determines, or has substantial influence over important decisions made by the company, including decisions regarding the nature, scope, attributes of the business of the reporting company, including the sale, lease, mortgage, or other transfer of any principal assets of the reporting company. That would seem to make sense if an individual had authority to dissolve the company. One would believe that he exerts substantial control. The definition includes, of course, reorganization, dissolution, or merger of the reporting company, or to suggest or require or mandate major expenditures or investments, issuances of any equity, incurrence of any significant debt, or approval of an operating budget of the reporting company. Compensation schemes and incentive programs for reporting companies is also likely to trigger substantial control analysis, the selection or termination of business lines or ventures or geographic focus, and will also likely require a filing of any such individual who exercises these sort of rights, and any amendment of any substantial governance document of the reporting company. Now, it includes the articles of organization or incorporation, bylaws, significant policies, procedures, and I would suspect shareholder agreements. Again, the definition of substantial control, as in the case of an individual exercising ownership interest, as a catch-all, and that is, has any other form of substantial control over the reporting company. Again, if we've learned anything from our analysis over the years of efforts to identify beneficial owners and to control malign individuals or forces, as the CTA refers to them, it is that FinCEN and these rules have cast a wide net, and in interpreting them, one is cautioned that it is better to over-report, especially in the early stages of the enactment and enforcement of this of the act, than to withhold. So if you have any question, or if you believe you exercise substantial control over a company, but you do not fall into any of the defined definitions, you probably do. And it would probably benefit you to have a robust comfort letter or client opinion letter if you are deciding whether or not to withhold reporting information from FinCEN at this point, in order to ensure that you are not willfully or at least causing another to willfully avoid filing or reporting, updating information through the FinCEN process. An individual may directly or indirectly own, control, and ownership interest of a reporting company through any contract, arrangement, understanding, relationship, or otherwise, including joint ownership with or more other persons of an individual interest in such ownership interest, through another individual acting as a nominee, and with regard to a trust or similar arrangement that holds such ownership interest, as a trustee of the trust or other individual, if any, with the authority to dispose of a trust asset. Of course, a beneficiary, and that is one who is the sole permissible recipient of income and principal from the trust, or has the right to demand a distribution of or withdraw substantially all of the assets from the trust. These are loaded terms too. In my view, the definition of income and principal from the trust does not have a threshold amount that would trigger the substantial control factors here for beneficial ownership, and distribution of or withdrawal of substantially all of the assets from a trust is also a curious use of language. What would satisfy the definition of substantially all of a trust mean? 40%, 50%? It's not defined. So one is again advised to use caution when reading the rules until we have further guidance from FinCEN. So moving on to slides 17, 18, and 19. We'll go through them briefly, which defines a company applicant. Once again, company applicants have to be identified in the initial beneficial ownership interest report filed with FinCEN for those companies created on or after January 1, 2024. And the rules essentially define a company applicant as an individual who either directly files the document that creates a domestic reporting company, is primarily responsible for directing or controlling the filing of the relevant document by the other, and is limited to 2 individuals. So a company applicant can be an employee of the reporting company, a secretary, a legal assistant, a paralegal, as well as the officer, whether a senior officer or an employee of the company, if they're taking this on themselves, who directed the filing. In the case of outside services, a law firm that includes a partner and an associate, the associate directed by the partner to file the document, the partner who directed the filing would be considered the company's applicants if in fact they did create the company after January 1, 2024, and would have to be listed in the beneficial ownership report. We're not going to get into here ethical considerations or practice of law or unauthorized practices of law questions as much, but a consideration to make and to weigh is who exactly will the company applicants be, the identities of them, and the extent to which the information they must report, the individuals must report to FinCEN. Well, a company applicant, so before we move on, let's make clear, will not include the Secretary of State's office. So the state filing office employees who process the formation of the documents in the ordinary course obviously are not company applicants. They're just entering the data into the database, not creating it. Employees of business formation services, if the service is only providing software, online tools, and the employees are not personally involved in filing a formation document. In other words, third-party filing companies are likely accepted from the requirement to identify these individuals if they are only funneling the information provided by another to FinCEN. Slide 18 talks a little bit about reporting rule, or rather, I would add that the final reporting rule dropped requirement to name the applicant for reporting companies formed or registered after January 1, 2024. And reporting companies created on January 1, 2024, however, must name the applicant, but is not required to update that company applicant information. So if the applicant, the paralegal, or the partner of the law firm leaves the law firm, it does not appear to me that information necessarily has to be reported to FinCEN. If in fact the individuals in the company applicant were involved in creating or forming the entity initially. There are a maximum of 2 company applicants required for disclosure, just 2, even if there are more. The direct filer and person primarily responsible for directing or controlling the filing. And it's important to note that the information required on the FinCEN form is the same as is required for the beneficial owner. And that includes, except it does not rather require the applicant's use of his residential address. It can be the company applicant's business address if the company applicant, that entity was formed or registered in the course of the applicant's business. In other words, sole proprietors, yes, you will have to provide your current residential address. General partners, yes, you will have to provide your residential address if you are forming as the company applicant a reported or reporting entity. But those that are otherwise registered with the Secretary of State or are officers or directors or controlling individuals, a company applicant that is created and has a business address, you will not have to provide that information. Coming into what are exempt entities on slides, and you of course can review the slides that discuss who is a company applicant, and of course now the exempt entities. There are in fact 23 current, and as you scroll through them, you might be picking up that these are all already heavily regulated businesses and therefore are not of interest necessarily to FinCEN. The federal government has all the information it apparently feels it needs on public companies through SEC filings. Domestic government authorities are presumed to know who they are and what they're doing. Banks, domestic credit unions, etc. I would like to perhaps just talk about a few of them, though, and those are tax-exempt entities. As you can see, tax-exempt entities and supporting entities are exempt, and the CTA exempts an organization that's described in Section 501C of the IRC, the Internal Revenue Code, that is, of 1986, as exempt from tax under 501A of the code. So any entities that are registered as private foundations or charitable organizations are exempt from this filing. And any of those of you who've filed applications for exempt entities, you'll understand why. They're very detailed and require a lot of beneficial ownership information as it is. Tax-exempt entities. The CTA exemption for tax-exempt entities continues for 180 days after loss of tax-exempt status. I'm unclear as to why that sort of change would not trigger the 30-day requirement of update, but it's significantly longer, and I suspect it's due to some favorable lobbying of Congress to have earned it the 180-day suspension, or rather extension or continuation, by which they would have to file an updated report of loss of exempt status. Exemptions or the tax-exempt category also exempts political organizations, and those are defined under 5271 of the IRC, and any charitable and split interest trusts as described in the code 4947A. If any of you have interest in any of these specific code provisions, we'll be happy to confer with you offline. There's no reason to get into them here, but it's important to note, in case anyone's wondering, since they are tax exempt, this exemption does not cover most homeowner associations. So HOAs, unless formed as part of the IRC Section 501C4 or C7, are not going to be exempt, and it's probably going to create a little bit of heartache for those of us who are among the participants or members of HOAs, and that will probably have to be resolved and is among those subjects that may result in an exemption. But at this point, beneficial owners, whoever they are, of an HOA are going to have to start thinking about how they're going to report this information to FinCEN. Accounting sarbanes, oddly enough, they're exempt. It applies only to public accounting firms registered under Section 102 of Sarbanes-Oxley Act of 2002. It's unclear to me why accounting firms, but not, for instance, law firms. But at the same time, many law firms will fit under the large business exemption, which we'll talk about later. Or why not just do it now? The CTA exempts any entity that employs more than 20 employees on a full-time basis in the U.S., has an operating presence and a physical office within the United States, and filed in the previous year a federal income tax return in the United States that demonstrates more than $5 million in gross receipts or sales in the aggregate or consolidated sales, which includes the receipts or sales of other entities owned by the reporting company and or other entities through which the reporting company operates. The large operating company exemption only consolidates revenue, not employees. So employees, the 20 employee rule requires that they be physically located in one or more offices based in the U.S. in any number of states. Reporting rules provide that only U.S. source revenue is counted for the exemption. And marginal companies claiming exemption, I'd suggest, need to constantly monitor the number of employees and annually check the reported gross receipts that it is disclosing. If either fall below threshold, the large operating company, if it was claiming a previous exemption, must file an update within 30 days. Inactive companies, in an active company is problematic in the sense that it's defined as any entity that was in existence on or before January 1, 2020, and is no longer engaged in active business. It cannot be owned by a foreign person, has not experienced any change in ownership in the preceding 12 months, and has not received or sent any funds in an amount greater than $1,000, either directly or indirectly through any financial account which the entity or any affiliate had an interest, and otherwise does not hold any type of assets, whether in the U.S. or abroad, including any ownership interest in any corporation, limited liability company, or other similar entity. This is obviously targeted towards holding companies, as the Act is clearly targeting is in its bullseye. It does not care whether or not it has any operating role, but if it does, it does not fall under the inactive companies and will have to be identified. Penalties for non-compliance. On slide number 22, the CTA provides, and this is a warning to those of us who are advising companies that are subject to the Act and the rules, that a person who willfully violates the BOI reporting requirements may be subject to civil penalties up to $5,000 for each day that the violation continues. There does not appear to be any ceiling on the aggregation of daily penalties. So if one is considering not filing a BOI report, one does so at one's peril. There is no relief provision except safe harbor discussion below. The Act also subjects individuals to criminal penalties of up to 2 years imprisonment and a fine of $10,000. Potential violations include willfully failing to file a beneficial ownership information report, willfully filing an incomplete or false beneficial ownership information report, or willfully failing to correct or update previously reported beneficial ownership information, including image identifying document. I don't want to get too much into that, but I see a host of problems with folks whose names have changed, who've aged over the years, whose identities or appearance have changed, that will require that they update their report based simply on the fact that their reporting document or identifying document is no longer what it was when it initially filed. I'm trying to move ahead here to give folks time to ask some questions. I'm about done. The final reporting rule, however, I'd like to remind you, provides that a person is considered to have failed to report complete or updated information if the person causes the failure or is a senior officer of the entity at the time of the failure. Those of you who are considering advising companies in this area and you instruct a company not to file, be warned. I'm not exactly sure whether civil or criminal penalties would lie. I should think that any willfulness or intentional act on behalf of an individual is not to be presumed in causing another not to file. I can think of instances when one might, however. I would rather not get into it. But if you have any interest in pursuing this area, let us know, and we'll let you know what we think the scope of any liability might be in this area. It's important to know that liability, though, will include not only an individual who actually files or attempts to file false information with FinCEN, but also anyone who willfully provides a filer with false information to report. And of course, willful is defined under the CTA, similar to other civil and criminal statutes, defining willfully as the voluntary, intentional violation of a known legal duty. The CTA does not require that the intent be malign or evil. Willful blindness is certainly within the meaning of willful, conscious or intentional disregard, and it employs also a recklessness standard in the civil context. At any rate, if you find yourself having filed an inaccurate report, there is a safe harbor, as I briefly alluded earlier. An inaccurate BOI report can be corrected within 30 days after the date the reporting company became aware of it or had reason to know of the inaccuracy. Now, it's important to note here that the safe harbor provision protects the reporting company that became aware of it or a reason to know. A company applicant that later becomes aware of it and has reason to know has no obligation to file an updated report. It's the reporting company's obligation to file, unless the company applicant and the reporting company are one and the same. A safe harbor is provided for the person submitting the BOI report if he or she voluntarily, promptly submits a corrected report no later than 90 days after the inaccurate report. So there's a 30-day within a 90-day requirement here. The safe harbor does not apply if the person submitted the initial report for the purpose of evading the initial reporting requirements and has actual knowledge of the inaccuracy. The last two slides, slides 24 and 25, talk briefly about other considerations. I think we'll just let you read them. I've mentioned the HOA consideration. I think a good practice for those of you who are listening now and are members of or potential owners or those having beneficial interest in companies that are targeted by the CTA, that you consider updating or ensuring that future shareholder agreements anticipate CTA reporting and updating, and should include a contractual obligation of shareholders to provide that information. I'm not sure whether or not directors and officers insurance is available for potential civil penalties, but that is something also to consider with your individual brokers and carriers. In terms of real estate centric issues here, I bring it up merely because, or principally because, it's the use of cash in real estate transactions that's really the focus and was the imprimatur of the FATF's recommendations or spotlight initially. As we know, those of us who've lived in other parts of the country, foreign investment in real estate is not uncommon. The use of cash in real estate is not uncommon. And there is increasingly a reappearance in a few states, at least, of alien land laws that are attempting to identify and perhaps even prevent ownership, foreign ownership of land. I will, I think, allow you folks the opportunity, if there are any questions, to raise them. And if not, I want to thank you all for participating or joining me in this today.